So first of all, our group 1, today have a very honor to present on the final research of our topic on patent, utility model, and industrial design. So intellectual property is a category of property. It's one of, like, we have immovable or movable property, and intellectual property is one of them. But intellectual property is invisible, which means that you cannot see, but you know it. You know that you have some people have those property. They are intangible creation of the human intellect. So the main purpose of intellectual property law is to encourage creation of wide variety of intellectual goods, which means that they encourage the development in society. Innovation encourage development of every society, especially the undeveloped country. Also, those inventors, the one that own those intellectual property rights, will need the protection, and the protection is only sufficient if the legal authority can provide it. So that's why they create intellectual property. And today, our group number 1, we only focus on 3 main intellectual property. They are patent, utility model, and industrial design. So why intellectual property right is very important? The first thing to think about intellectual property right is to protect those inventors. And when we protect those inventors will continue to produce the amazing invention when they sure that their invention will be protected and will not be commercially exploited or taken away by those who infringe their intellectual property right. And also, intellectual property right also play a role in increasing investment. When the company they can maintain that their intellectual property right was protected, they will invest more in those countries. So it's also provide increasing income, and especially the exclusive right to the inventor who created them.
Okay, so now let's move back to my part, which was talking about the historical background of the patent. So according to the researcher has found that the patent system was created long time ago. I mean, the patent system was created since the ancient Greek during the 500 BC. It means before Christ. And after that, the patent system was developed more detailed as the first patent law through the Vatican patent statute, as we can see over there. Yes, and after that, the patent system law was also practiced by many countries in the world. And and later on, the patent system was also developed more and more through the generation. I mean, it practiced. I mean, the patent system was practiced slightly differently from another country to another country by the next generation of that period. So now let's move to the second one, which is called the utility model. That all of us know that it is the type of the patent. So based on the research, the utility model was created on the 1st June 1891 by the German Act on the utility models. And during that time, they create the utility model. In order to protect the new industrial property right for the inventor. And so here you can see the utility model or utility patent platform.
Thank you. My name is Omberto, and I'm going to present you about the industrial design history. Industrial design history was used in a long time ago, but for the first record the 4th century BC in China. China was created the first crossbow and some other weapon, example like sword. And for the design moment timeline, it was recorded from 1850 until present. The first is art and craft moment from 1850 until 1915, and until it was developed until now, until present, the constructivism from 1980 until present. That's all for the design moment timeline for industrial design from 19th century until 21st century.
I'm going to continue to talk about the main thing of our research paper. So the first right that we have mentioned, the first right that we have mentioned is about the patent. So what is patent? Patent is a kind of document or certificate that provided by the official authority, the state authority or regional authority who are responsible for those parts. And it is provided by only upon the application, and it's create a legal situation which the patented invention can only be exploited, manufactured, used, sold, or imported with the authorization of the owner of the patent. So in a very simple word, it's like you create something awesome, then you apply it for patented, the legal authority will protect you that your invention will not be exploited, will not be stolen by the other, will not be manufactured again or sell without any authorization of yours, of the inventor. And also, to understand about the patent, we need to understand about invention. Invention does not mean everything. It is only about the technical sector, which means that they can be the solution or a product to specific problem in the field of technology. And for the invention, we only have two kind of invention in terms of patent rights. The first one is about production invention, and the other is process of invention, which means that the product invention, when you create something, that something is called production invention. But if you create a method in creating something, that's called process invention. Next slide, please. So, in the application of applying for patent rights, an individual or the inventor or the owner of the invention must meet 5 categories, must meet 5 requirements to apply for the patent. And those requirements was called condition of patentability, or we call, in a very understandable word, requirement of patentability. So in the requirement of patentability, we have the first one, which is the patentable subject matter. Mostly in national law of every country, they do not define patentable subject matter. They tend to define it in a negative way, which means that they do not say what it is, but they try to say what it is not. So, in patentable subject matter, according to the U.S. Trademark and Patent Office, they define the term patentable subject matter. One invention can be a patentable or can be a subject matter of patent. They must fall into 4 categories. First, process, second, machine, third, manufacturer, and the last one, the composition of matter. And they must be patent eligibility, which means that they must not fall into the legal exception. So the legal exception that we have in patentable subject matter, they consist of discovery of material or substance already existing in nature, scientific theory or mathematical method, plant or animal other than microorganisms. So in word, something must be created in patentable subject matter. It needs to be created by the inventor. It should not be already existed in the nature. The second requirement for patent is the industrial applicability, which means that it must be available for practical purpose and not theoretically. And industry should be understood in a very broad sense in this intellectual property right, which means that it can be include any sector in industry. The third requirement is novelty. One invention can become a patented invention. It needs to be new, and it's not part of in the prior art, which means that it should not be created already. The fourth one is the inventive step or non-obvious. We call non-obvious. So it means that the invention must be a result of creative idea. It should not be simple. It should be expertise with skill and creative idea. And also, the step must be essential to the invention, which means that the ordinary skill of people cannot be produce this invention. Only the inventor itself can produce it. The last one, the fifth requirement of patentability is the disclosure of invention. After you already successful in the four category already, you need to disclose your invention in the application clearly in the best mode with some example that it will be able for the ordinary people to create it. Thank you.
So I just want to brief you about what is exactly a utility model. By the definition provided in the law, it is quite a bit similar to patents for the fact that technical inventions are protected by utility models through offering short period of right to prevent others from commercially exploiting the right and the protected products right, without any consent to the owners. And the period of protection in utility models is usually protected about 6 to 10 years, but the practice of different countries may be different. Some countries may be longer than 10 years, like 15 years, some sort of that. And let's get back to the previous slide, the previous one. Thank you. So what are the differences between utility models and patents? For utility models, it is less constringent. It means when you access for utility models recognized letter, it's less strict than for patent. And the term of protection is shorter than patents, and it protected for the fields of technology like mechanical or apparatus, some sort of that. And it's cheaper because the protected period is shorter than patent, so utility model is cost cheaper than patents. And the registration process is easier and quicker. So people who want to get their products being registered at the patents office or utility models office, the registration process is easier and quicker. Just taken around 6 weeks or less than that to get the utility models recognized letter by the officials. Thank you.
Okay, so let's move to my class. I'm gonna present about understanding industrial design. So let's start with what is exactly industrial design. So in some of my research, according to WebPo and another research, they mentioned that industrial design is an expert of processing design, customer products by many people, and it consists of some dimension feature for exactly 3 dimension feature. So it's talking about shape of the article, and another 2 is featuring of the pattern, line, and color. So it's I just to sum up the industrial design meaning, so that it is kind of the way of visual appearing of the product that they design uniquely, I mean like originally. So what is industrial design right? So industrial design right is the form of intellectual property right to protect the design object that provided by the creator, the creator product or any objects that invented, the new invented creative that is original. So the point that is this industrial design right is try to protecting the way how their product created, shaping of the products and the color, the line of the product, color of product, something unique that original. So why protecting the industrial design? So let's start with the points that if you go to market, I mean that most customers are focusing on the visual appeal of the product. Like this one is look more classic, or this one is look more technology, or something like that. So example that you have 2 products, I mean like 2 computers. Let's say computer. 2 computers that have the function inside the same. They got the same RAM, they got the same CPU, the same thing, the same functioning, and they both can do the same thing, functioning with the same thing, the same window or something like that. But the point that how can we judge that which one is used both? So you can say they judge by the quality of people using before it. But when you see, when you go exactly to the market to see the 2 computers that function exactly the same, of course you're gonna look at which one is looking better, which one is more attractive to you, more technology. Talking about computers, so more technology, more high technology, something like that. So the high technology or the appearance look of the computer is what we call industrial design. Then how they design. So protecting it by register to register it so that they can have your industrial design have the rights. The rights that no one else, no other company, no other computer company that can copy that exact design of your computer. So this is how you protect the industrial design and why we need to protect it.
My name is Manspander. I'm going to respond for the international and the national law related to the intellectual property. So what is the intellectual property law? The international intellectual property law refers to the law that is a kind of the legal framework agreement of the state member in the World Intellectual Property Organization. And the WIPO was created in 1967, which is located in the Geneva, Switzerland, within 191 member states. Nowadays, there are many common types of the intellectual properties, include the copyright, trademarks, patent, industrial design, right, and so on. In case of the member of the WIPO has any dispute, they will sue the case to the WIPO's arbitration and the mediation center to find a solution and consult in order to slow the case. For the national law, the Cambodia has accession in WIPO on May 31, 1963, and it's coming into enforce on November 1963. And we also joined the 16 multilateral and bilateral international agreement. Now I rest only the 3 agreements, such as the Cambodia, Singapore on IP cooperation on 20 January 2015, threat-related aspect of the IP rights in 2004 and the ASEAN EU's on IP cooperation in 2014. Furthermore, we also adopt the law on the part-time utilitarian models, utilitarian model and the industrial design by our National Assembly on the November 28, 2002.
Okay, now our presentation has reached to the conclusion, and now I would like to briefly talking about the three types of intellectual properties. And the first part of I would like to talk about is patent. Patent is prevent other person or party to making use or sell this type of invention with acknowledged from the owner of patent. And the second one is utility model. Utility model measure security and utility of any project or circumstance that can be considered. And the last one is industrial design. Industrial design is considered to be the protection of the product that the design of object provide to create the product of any object more invention and creative. And to sum up, as you know that it is important to have these three types of intellectual property in order to ensure the process of any business and the working of the process in their own way. Okay, so our presentation have come to the last. Here we got the recommendation that we would like to propose some point in order to take the intellectual property law to be more globalization. So the first one is to ensure the incentive need for product development and manufacturing. And it can be making the better technical progress as widely as possible. And the third one is using intellectual property as a tool to facilitate global success. The first one is strengthen enforcement and legal practice. And the fifth, create more appropriate price on the application on this right. Providing more information on any news update on intellectual property law. Creating institution focused on consulting SMEs to understand and practice intellectual property law. And the last one is increasing the rank of intellectual property joint World Intellectual Property Organization. So we have come to the end of our presentation.